Aha.
Thank you for attending our presentation. Take it away, Gagan.
Hi everyone, today we're going to present about the ABCs of worker misclassification. My name is Gagan.
I'm Rianka.
And I am Audrey. We are all 2Ls, and this is our first semester with the Low-Income Taxpayers Clinic at Lewis and Clark. As part of the work that we do in our first semester, we present an advocacy project to members of the general public. And what we decided to focus on for our semester is workers, and primarily a slight focus on gig workers in California and Oregon. So we're going to talk about that. If you'll go to the next slide, please. Thank you. We're going to start off with this outline of what we're going to be covering. So first, we're going to go through the goals of what we intend to present to you and why we're doing this. Next, we're going to go into a definition of what misclassification is and why you should care and how you can know if it affects you. We're going to look at some current issues, some case law and some ongoing laws and legal debates in California and Oregon. And we're going to talk a little bit about what the legal climate looks like in regard to misclassification and gig workers. And then we're going to end with a discussion of what you can do, what steps you can take if you find that you are misclassified. And then we'll have some time for questions. So let's go.
All right, so we have 3 goals of our presentation. The first goal is to educate you about the tax implications of worker misclassification.
We also want to aid in recognizing when worker misclassification has occurred.
And last, we want to provide resources for individuals who have been victims of worker misclassification.
Next slide. Great, so the first issue at hand, before we get into any of the legal jargon and the case law and anything like that, the biggest issue that we want to focus on is, what is this? I think most people don't know what misclassification is when they start working, but it actually affects tons of people throughout the country every year, and it has huge implications. So in essence, misclassification is when your employer classifies you as a worker or classifies a worker as an independent contractor rather than an employee. What this ends up meaning for the employer is that they're not paying their fair share of a worker's taxes. So an employee or a worker will have to pay their own Medicare and Social Security taxes, which can put quite a burden on an individual. It also means that that worker's income, their unemployment, their Medicare, their Social Security benefits aren't as available as benefits to the other workers at their place of employment. And it also means that in the grander scale, it's not available to workers throughout the country. So it actually really ties into pretty much any tax issue that an individual might have, and it affects everybody.
And just going off of what Audrey just said, there's a lot of consequences of being misclassified. If we can go to the next slide, we kind of listed them out. Mostly it's wage underpayment. So you often aren't getting the industry standard for the work that you're doing because they can find a way around it. And sometimes people aren't even getting paid the minimum wage. There's diminished benefits because you don't qualify for employer sponsored benefits. So you're responsible for getting your own. And if you don't know you're misclassified, you're not going to know to get your own benefits. And there's less protection in the workplace. Well, you're not a part of a union. You're not a part of a lot of the workplace policies that are put in place because you're not an employee. And there's double taxation because when you're an employee, you pay your share of the taxes and the employer pays their share. But if you're not an employee, you're paying both of them. So that in that sense, you're getting double tax, and you're ineligible for employer-sponsored retirement accounts, and you're ineligible for workers' compensation coverage. So if you're injured on the job, chances are you're out of luck on getting any medical help, any paid time off, or and stuff like that.
Okay, so for the next slide. So as far as the impact on individuals, if you don't know about it, you're unlikely to know that there's a ton of people that are impacted by this. So 3 of those groups are people such as undocumented immigrants, and Gagan kind of laid out some of those reasons as to why they might be targeted and how they're misled about their rights and tax liabilities. So this can be anything from a worker being a gardener to somebody that's like a person working in a hotel that might be part of cleaning services, And as we'll go through the presentation, we have a focus a little bit about gig workers. So this includes apps such as Uber, Lyft, and as well as like grocery delivery services like Shipt, things like that. And there's about 16% of US adults that make money through these apps. That really is a large percentage of people that are being directly impacted, let alone their families that rely on them for that specific for that employment, and then how they're also missing out on if they have to help contribute to like a workers' comp issue. If they can't get it through the employer, then the family has some economically detrimental issues that arise. And then as far as the other large industry that is really impacted by this would be a lot of farm workers. So there is a lot of overlap with farm workers and undocumented immigrants. And so they are very likely to be misclassified and taken advantage of. And they're in very physically laborious positions, and they're oftentimes vastly underpaid. And so if you look at this chart down here, we see that these are numbers from Oregon, specifically from 2015 to 2019. So there, as far as the payroll, there was over $131 million of payroll that was being unreported. So these are benefits that employers were getting and ones that employees were ultimately they were suffering through these. And the number of employees that were being impacted was over 16,000. So when you look at a state like Oregon, that really is a large percentage of the people that are getting impacted. So it's not an issue that's just a theoretical number. Like there is millions and millions of dollars of financial hits to these employees when they get misclassified.
Great, next slide, please. So one of the reasons that so many people, as Rianka was saying, get misclassified is because they don't know essentially what their rights are and what their position means. So we've talked a lot about definitions and who's impacted, and we keep throwing out the word independent contractor, the word employee, and sometimes we use them interchangeably and sometimes we don't. In this specific field, independent contractor and employee mean vastly different things. So an independent contractor is someone who would pay their own taxes, and an employee is someone who the employer will pay their taxes for them, as we've been discussing. So here we have the actual legal definitions in Oregon, and we'll go through them, so don't worry too much about the legal jargon and the definitions of the bigger words, because we still don't know all of those things. That's what we're in school for. So an independent contractor is a person who provides services for remuneration or for getting paid, and who, while they are providing these services, is free from direction and control over the way that they provide those services. So contrasting that with an employee has a lot of rules that they have to follow. An independent contractor is pretty much free to decide how they do their job, when they do their job, potentially where. They also, generally in Oregon, you have to be customarily engaged in an independently established business, which means that in many cases, you have to hold yourself out as an LLC or your own business, which makes it much harder in Oregon for employers to misclassify people. And these are some pretty recent developments in the field of workers' rights. Versus down here, employee. An employee is an individual, anybody who is contracted by an employer. So we see that employee is a much vaguer definition, and independent contractor is very, very specific. So in Oregon, when people do get misclassified, it's pretty much a huge breach of the law. Next slide. Okay, I guess we got rid of that one.
How to tell if you are affected by whether you're classified as an independent contractor or an employee? It depends on the.
We go back one. There we go.
Depends on the.
Oh, wait, go up one there. That's where I wanted to be. Okay, fantastic. So the definitions and the differences. The laws and looking at the way the laws are laid out can be very confusing. And in some ways they're meant to be that way because it allows courts to argue. So this chart that we have found actually lays out the differences really, really clearly and contrasts them against each other. So employee over here on the left means The means and manner of work are controlled by their employer almost entirely. Independent contractor, you're free from direction and control. The employee has to do the tasks the way their employer designates. The independent contractor gets to do their job their own way. Employee, going down a little, has a place of business at the employer's business location versus the independent contractor has their own business location. This can be a home, it can honestly sometimes be your car, it can be an office, or sometimes it can be yourself. But the place of business is not housed by somebody else. And then another important one would be that your employer purchases your materials and supplies for an employee. Versus an independent contractor would purchase the materials and supplies needed to do the job themselves and maybe get to deduct those from taxes at a later date. That's one that'll actually come up later in our presentation and ends up being pretty significant. Let's keep going.
So now, how to tell if you are classified as an employee or independent contractor usually happens around tax season when the employer is giving you your tax forms. Usually when you get a W-2 form, this is the form that gives you the important tax information that are related to your earnings, your tax withholdings, benefits information. And it's what you provide to the IRS when the information to the IRS when you're filing your taxes. And usually if you're given a W-2, it means the employer is classifying you as one of their employees. And so they are paying their share of the taxes on your behalf and withholding taxes for the IRS from your check as well. Now, if you get a W-9 form, this is a little bit different. It's given to you by the business that you're hired to work for, but it's given to you to fill out yourself. And so it's used to report the income that you've received other than wages. And this is, if this information is used to get a 1099 tax form. And that's between businesses, like it's business taxes, and it usually dictates how much tax you're going to pay. So if you're given a W-9 form, chances are you're being classified as an independent contractor by your employer.
Next slide, please. So as far as different states go, because one of the things to keep in mind is that there is a difference between state law and federal law, and then states do not follow the same law as each other. And the way that they determine if somebody is an employer or an employee versus an independent contractor, usually the state or the employer will look at different tests. So there is a variety of them, and some states have gone certain ways. So if you look all the way on the right side of the chart, there's the ABC test, and that's a test that California, for instance, does. And what they're looking at, you're more likely to be considered an employee in a place like California. And then on the other side, you're less likely to be considered an employee, but depending on the level of direction that you might get. So going through these three tests, the right to control test, the essence of that is essentially in a given task or in a certain job, how much control does the employer have over the worker? So are you determining your own hours? Are you determining where the jobs will be done? How are you getting paid? Who's getting equipment? Are you allowed to leave a job at any time? Are you going to get fired? Or can you simply just be done after a specific contract? So that's the right to control test. And there's numerous factors in all these different tests, but here's just some of those. Versus the economic realities test. And this has to do a little bit more about what's happening on the financial side of things. So this is how much control does the employer have and what is the nature of the work being performed. So this, for instance, is relating to not only how much money is a person making as an employer, independent contractor, how much is the employer being able to withhold from you? Is the skill that you're bringing to this job, is there going to be more profit or loss? And the degree of permanence of the working relationship kind of goes to that, like the hiring and firing of independent contractors. They have to complete a contract when they contract with an employer versus an employee that might be at will and can just leave in the middle when they decide. Now going down to the ABC test. So there's three tenets of this one. And this is a really strong test on the worker side because there is an assumption, a presumption that a worker is an employee, period, unless these three elements are met. And so this goes back to, like I said, a lot of these factors will overlap. So this one we see the direction and control, the hiring entity in connection with performance. That's kind of going to be the big part of this one. The second one is that the worker is performing work that is outside the usual course of the hiring entity's business. So for instance, with like Uber and Lyft drivers, all of Uber and Lyft is about driving people that hire that service around. There's nothing to do outside of that. Whereas a place like a hotel, their work is to get people to stay in their rooms. And so all the work that is attached to that is somebody that would be an employee versus somebody that might be considered an independent contractor to do work such as gardening outside. Whereas you could have a gardener, you might not, but that doesn't have the same impact about the running of the business. And then the third one is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So in the hotel instance, you might have front management, you might have people cleaning, but it's all really around that. Versus this one's a little bit closer to Uber and Lyft, where they are doing the exact nature of the job as being done. So as far as you, if you're trying to figure out if you're being misclassified or not, you can kind of look to some of these factors. We have to make sure you know that what your state is doing and how to most favorably make your case for the state that you're in. Like I said, the federal government has different things that they look at, but these are just some of the tests that are used to determine, are you an independent contractor in that state, or are you going to be considered an employee in that state? So if you go to the next slide. So these are kind of some of those issues that are boiled down. So are you providing services for remuneration? Are you free from direction and control? Are you an independently established business? And have you obtained required licenses or certificates? And if you do, then you're an independent contractor. So if you're somebody that owns your own business and you are like a hair salon, you're the one that has to make sure as the employer that you have a certificate or a license for that business, and the people under you are the ones that are using your certificate. So that's where you would be considered the employer. And so you wouldn't necessarily say that underneath them, that maybe a hairstylist that you hire is an independent contractor, because they're still operating under the license that the employer has provided for you.
All right, next slide. So this is another visualization of what these tests look like, a little more so in practice for us. So if you recall on the slide that Rianka was talking about with the scale of the tests, this is sort of another version of that. So on the far left, ORS 670.600, this is Oregon's legal test. And so for that, there are these 4 factors: free from direction and control, customarily engaged in an independently established business, licensed under these 2 other laws, and responsible for other licenses or certificates that are necessary to provide a given service. So in Oregon, for example, a gardener may require a number of different certifications to provide particular services. So on top of being a licensed contractor, they must also have these other licenses, and they're responsible for that. You may hear that that sounds very similar to the ABC test, and that's because it is. This is the Oregon specific ABC test. And then over here in the middle, the economic reality test. This is sort of, whereas our Oregon statute has this really significant presumption that an individual is an employee and an employer has to prove very, very clearly that an individual is an independent contractor, the economic reality test can sort of go either way, as Rianka was saying. And you see here we have those 6 factors laid out a little more specifically. And then on the far right, right to control, presumption that you're an independent contractor, need to prove that you are an employee. And that burden would be on the employee rather than on the employer. And you see that there are very few and vague factors for that. So a much easier test for an employer to prevail under versus this Oregon rule that we're currently working under. That's much, much harder for an employer to prevail under. All right,
So
next slide, please.
our first example is a Broadway Cab LLC versus Employment Department. This case came out of Broadway Cab. They are one of the biggest cab companies in Portland. And in 2008, 2009, they were given a tax assessment by the Employment Department saying that they had not been paying their share of the unemployment tax. And they had challenged it, saying that they don't have employees, but they actually have independent contractors who are cab drivers. And so when this went to court, the court looked at the ORS 670.600 test that Audrey just went through to see if the cab drivers were actually independent contractors or if they were employed by Broadway Cab. And what they found was that while Broadway Cab argued that because the cab drivers are getting all of their compensation through the riders themselves, it wasn't getting passed on to Broadway Cab and then shared with the cab drivers. The riders would pay the cab drivers directly, that they were not considered independent, they were not considered employees. But the court found that because Broadway Cab required every cab driver to not only sign a driver agreement that dictated how many hours they would work a day or a week or a month, it also required them to drive a car. It could be their own, or they could lease it from Broadway Cab, but it had to have their emblem on it. It had to be a specific color, and they had to pay Broadway Cab for licensing and other other fees for leases. So the court looked at that and said that this actually passed the ORS 670.600 test, that they weren't or didn't pass it, and that they actually were employees. So Broadway Cab ended up having to pay for their employment tax on this.
All right, next slide. So jumping off of that, 3 years later, and this is one that probably a lot of people have heard of, was the O'Connor v. Uber case. This is colloquially referred to as the Uber case. The issue here was very similar to the Broadway Cab case that Gagan talked us through. But the issue for the Uber drivers was that Uber was not giving them the gratuity that they were given by their riders. So if anyone has driven for Uber, you know that when you get paid, it doesn't go directly to you per ride. It goes to Uber and then comes back. And the tips that drivers were getting from their riders were being treated the same way, which, without getting too into the weeds of it, violates a California labor law, regardless of whether or not you're an independent contractor or employee. That said, when it came up in court, the issue arose and started to stick to this question of whether Uber drivers were independent contractors or whether they were employees and were not deserving, but warranted the rights that employees have, especially the tax benefits. So this case got a little bit complicated because of class action issues. And so while the outcome of this case didn't end up changing legal precedent, and it didn't really become a law based on what the outcome was, the reasoning, the discussion was very, very important. So the issue that arose was the question of whether or not a person providing a service to a company, whether that service creates a presumption that that person is an employee of that company. And that phrasing may sound familiar, and it should, because that is what eventually has become the baseline of this Oregon law that we have. The court decided that, yes, because Uber could not function as a business without the driver's contributions, there was this presumption that the employees, the drivers, were not independent contractors. The biggest thing to take away here was Uber as a company has some employees that maybe work in an office somewhere, but the majority of their revenue, the money that they make, comes from these rides. The fact, if you removed the drivers from the equation, Uber as a company would not be able to stand. California says, okay, well, with that being said, if that's the case, then they have to be employees. If your business cannot run without these individuals, we cannot say that they are coming in to provide a service that you can't provide in-house. Without these people, there is no in-house. It's sort of, I think that the analogy that we've used is if you have a business and you hire a gardener to come and garden, that gardener is not an employee. They're coming to provide a service that you cannot provide yourself. But if there is no business going on in the place that gardener is working, then there is nothing happening there.
And if we go back to Broadway Cab as well, 95% of their revenue was coming from the drivers, from the income that was the work that the drivers were doing. So the court also looked at that, saying that the cab company could not survive without the drivers. And so the service that they were providing was directly related to the work that the cab company was doing. And so that is a big factor.
Mhm.
Mhm.
Next slide. So I speculated a little bit, speculated that after the Uber case in 2018, that might have had some bearing on this law that came into place in California. So this law is Assembly Bill 5 or AB 5, and in 2019, the governor did approve of this, which required that gig economy companies like Uber and Lyft treated their workers as employees. So this was hugely in favor of workers' rights. And in general, it's a system that we're kind of seeing states move towards. It's a trend that's starting to happen. And there's a lot of factors that go into a decision like this. And there is some contemplation about what sort of economic fallout might there be on the people trying to get the rides. In response to when this bill was being proposed, gig companies such as Uber and Lyft actually spent over $20 million to try to fight this law. And they wanted to say that it was unconstitutional, that there was meddling into the business practices of these companies. And what essentially happened was that they said that it was constitutional, that these related to the rights of these specific employees. And so Proposition 22, they exempted those companies from those laws by classifying those workers, so the Uber and Lyft drivers and other such ones, as independent contractors. So this is very much so in favor. And like I said, in 2021, eventually when it went to court, it was, they said that California held that Proposition 22 was constitutional. I'm sorry, the proposition was unconstitutional. Sorry about that. And struck down the measure. And so AB 5 was actually able to stay law. And as of today, it does remain in effect and it protects those economic workers from harmful misclassification. So going back to those slides, when I was talking about those numbers, in Oregon, it's 16,000 plus workers that were impacted, and California has a much larger population. And so the amount of big cities that have workers such as Uber and Lyft, they really have had a lot more protection because they have so much more business that's happening over there. So it's really interesting to kind of see the back and forth happening in California and the potential trickle down that might have on other states, such as Oregon. And in general, as more states are starting to get a little bit more seeing these supposed independent contractors as employees. So now they're getting a lot more of those rights and protections and financial benefits provided to them.
Yeah, it's sort of a power shift that we get to see. And I think the progression of cases that we have shows that really well. I think Broadway Cab in 2015 shows this presumption a little bit towards employer rights.
Mhm.
And then the O'Connor v. Uber case shows this sort of middle ground between employer versus employee rights, and the AB 5 bill shows this paradigm shift into caring more about the worker than the employer. And I think it's been very interesting because it's taking stock of who has power in a dynamic and allowing the laws to shift in favor of who needs protection, which is what the law was supposed to be made for in the first place. All right, next slide.
So now, if you believe that you have been misclassified, one of the first things you should do is talk to your employer and see if it was a mistake on their part. Maybe you could get it fixed, and you could just fix the problem right from the source. But if that's not something that you can do, or they don't believe that you are an employee, the next step to take is with the IRS, and that's to fill out an SSA form. And now this form, you fill out exactly what your duties are, exactly what you do. And if you could click that link, we could show you an example of the form. And basically what the IRS does is they gather your information and they assess what you do and kind of decide whether your duties line more onto being an employee or whether you're an independent contractor. And if they decide that you are an employee, they will give notice to the employer and tell them that they have to file the correct paperwork. And usually what that means is if you're being misclassified, chances are other people that you work with are being misclassified, which also means that the IRS is missing out on a lot of tax that they're not getting because of this misclassification. So usually they will help you get this all sorted out. The only issue with this is that, you know, the employer will find out that you filed this. So a lot of people are hesitant because they don't want the employer to know, and they're afraid of retaliation or being fired or anything like that. So I think generally it's a good idea to just seek out the assistance of an attorney who can help you fill out this form, but also can navigate the steps afterwards, once this has been filed and once the IRS has made their decision. And if after all of that, there's still some things that are just not being sorted, or the employer is doing other bad stuff, because usually that's what they do, you can also file anonymous complaints and take it that way too. And also unionize, because, you know, workers' rights, and that will nip it in the bud.
They'll stop all of this from happening right at the beginning.
Plug the union.
Yeah.
Workers' rights first.
All right, next slide. Awesome. So just bringing it home, some resources. If any of this has resonated with you or you would like to learn more, please feel free to take advantage of some resources that we've compiled. So if you would go ahead and click on that link, Professor. We'll see how fast it comes up for us. These are some resources from, I would love to tell you. Yeah, the Oregon Department of Revenue. So these are some compiled resources that can help you out if you need help. And there's a lot here, but the most important things that you want to look at as an individual are going to be the general information section. If you click on any of those links, tax forms and publications, the DOR homepage, those things will take you to sites that have more resources that you can explore on your own to educate yourself. The FAQ will be particularly helpful in that regard, because any question that you have, likely another person has had it before, and it will be listed in there. After that, this individual tax overview is another place you can go and explore, and will give you resources, contacts, links. Sometimes they even have educational videos and slideshows that can help you educate yourself about your rights. And then from there, the withholding and payroll taxes. All of those contacts are going to be beneficial to you if you believe that you are dealing with a misclassification issue, or if you just have questions about what your situation looks like. Very often, we've given you a bare bones, and if you go back to the slideshow, that'd be awesome. Thank you. We've given you a bare bones, overview of what misclassification is, but the reality is that these issues are so much more complicated and so much more convoluted, just, by necessity, and sometimes on purpose by an employer to, hide the ball a little bit. So if you are unsure of what your situation is, please feel free to explore those resources and figure out who you can talk to. Additionally, something you can do is take advantage of the resources that we have posted here. This is a form that we have in-house here at the LATC. We've got a list of attorneys that have agreed to do free consultations down here at the bottom, which is very great, because one of the biggest issues, we can say all day, go get an attorney, talk to a lawyer. But realistically, that can be quite prohibitively expensive for a lot of people. So if you talk to any of these attorneys, they will give you a free consultation and point you in the direction of someone that can help you. Or the Oregon State Bar Referral and Information Service, they will give you the name and number of an attorney who will give you a $35 consultation fee. That the Oregon State Bar Referral and Information Service will direct you to someone who specializes in exactly the issue that you're having, and you pay $35, you have a consultation. And they as well can point you in the direction of someone that can help you more. Yeah. All right. So are there any questions? I'm not sure over this medium how to field questions.
Well, we have several viewers, live viewers. Yay. Thank you for joining us. But we don't have any questions, I don't think.
Speaking, hold your peace.
Forever.
If you don't have any questions, there's no hope.
Let's see. Oh, wait, we do have a couple questions.
Great, let's go.
So Will Colburn asks, what might be some examples of other gig economy companies? Is it just rideshare and delivery services among workers involving a worker's car?
That's a great question. The answer is no, it's not just your car, any gig work. So this could be freelance editing is one thing that a lot of people do. One specific website I can think of off the top of my head would be, I think it's called Fiverr. Yeah. But I don't know if you guys can think of anything else.
There's some
Yeah.
apps where it's not like Uber and Lyft is just for driving, there might be delivery, but apps like this, you can hire somebody out for like, if you want to like get a ride somewhere, if you want them to come build like furniture at your house, if you want somebody to do any number of different things. And so because those are all like very specific to like one thing, and it's just like a one-time thing, it's like, okay, you're probably more likely to be
Mhm.
an contractor.
There's also like traditional ways that you could be an employee or an independent contractor, like for example. If you work for a hair shop and you are a barber who either rents a chair or you're hired to work at that place. It gets a kind of iffy there, because if they're dictating when you're coming to work, like when you leave, who your clients are you giving a share of your, what you're getting paid to the employer, or are you keeping all of it? And all of that kind of gets sticky too, as well with landscapers, there's gardeners, but there's also I forgot who the specialists are called, the ones who do the
Botanical.
Like design,
botanists.
botanists, yeah,
There we go.
sure.
Yeah, like botanists, like usually you hire them because they're so specialized to do a certain thing, but other times if like gardening is something really particular to your company, chances are you're gonna hire them on as an employee. And a lot of employers will try to get around having to pay them the wages that they deserve, and try to pay them as independent contractors and like cut their wages a bit, cut their taxes a bit. So it can happen in almost any job.
Yeah, and that's the whole thing with gig work is your boss, if it's Uber, if it's TaskRabbit, they want to classify you as an independent contractor because it's worse for you and better for them. So there is an assumption by anyone that starts doing Uber or TaskRabbit or anything along those lines, rents out a space in a place to cut hair,
Yeah.
that you may be an independent contractor. But as we've talked about here, the rules in Oregon are actually so much more specific. And there is a very good chance that even if you are doing work through an app or renting a space, that you may be an employee of the place that you're working. In which case you should be afforded better benefits and better tax rulings.
We actually have 2 more questions, so
Great, let's
we
go.
need to cut off this wonderful answer. The second question is also from Will. Is there a statute of limitations that would apply in this situation? If you feel like you're misclassified in a prior year, how long would you have to bring a claim?
It should be the time that you have to edit or appeal something about your tax return, which I believe is 3 years, right? Yeah, I think
Or you have 3 years from the due date of the return to claim a refund, or 2 years from the date of payment, whichever is later.
there we go.
Yes.
So depending on what you're seeking and when you're seeking it, either 3 or 2 years. Ask an attorney.
Ask
Ask an
Ask
attorney.
us.
That is true. That's a really good comment. Okay, we have one more from Celeste. If you've already filed your taxes for the year, you're afraid you may have been misclassified, is there anything you can do?
Yeah, there's easy answer. There is always something you can do, especially where tax is involved. And the easiest thing that you can always do is find someone who specializes in this and ask them specifically about your situation. This would be a place that the resources that we laid out would be really, really helpful. And even if you're interested, shoot a call or an email to the LITC and we'll see what information and general help we can give you. But the short answer and the easiest answer is, yeah, there's absolutely something you can do. And if it was this year, if you're worried about the 2022 tax year, then you absolutely can do something about it.
Yeah, and you can always amend your return to classify your wages correctly, but it's a little tricky. So I would suggest definitely contacting an attorney that specializes in in worker classification and tax issues. I don't see any other questions. So thank you everyone for joining us today, and we'll see you next semester.
Thank you. Bye.